I'm really pleased that we were able to get you some ethics credit this morning. To my left, Jill Esenwein, hope I've got that right.
Esenwein, close.
Esenwein, okay.
Yeah.
And Olubunmi Ijose
Yeah.
is, they have both come up from Indianapolis this morning. They work for the Indiana Supreme Court Disciplinary Commission. They're going to talk to you about some of those professional responsibility things and how to avoid, to the best of their ability, showing up on their radar.
Thank you. My name is Jill Esenwein. I'm a staff attorney with the Office of Judicial and Attorney Regulation. And we are both here today to kind of talk to you about the general topic of how to handle client complaints, particularly in the age of social media and responding to reviews and kind of some ethical considerations for you. I am happy to be here and that Amy invited me because I am also the liaison for St. Joe County and some of the northern counties. So if you as a bar association have questions or concerns, I can be reached that way via email. The other thing is I am from the area, even though I live in Indy. I grew up in Wakarusa and my family lives in Elkhart. So I'm very happy to be back up here in this area, which I consider my home. So just kind of a quick overview of our objectives today. We just want to give you a brief review of our office because it's kind of newly named last year. I'm going to review discipline decisions from across the country that have come down recently regarding social media and responding to things online, and the two decisions here in Indiana that specifically were attorneys who were disciplined as a result of their conduct when responding to reviews. And then Olubunmi will be reviewing the ABA formal ethics opinion for 96. That concerns and that gives guidance to attorneys also about how to respond to reviews. And there are also other states that have looked at this topic and provided their own ethical opinions. And then we're also here to kind of give you some best practices in responding to online reviews. So just briefly, as I said, our office is now combined with all three commissions. So it contains all of the staff for the Disciplinary Commission, the Judicial Qualifications Commission, which does the judicial discipline, and the Judicial Nominations Commission, which does stuff for the Court of Appeals and the Supreme Court for the judges. Adrienne Myring, who some of you may have seen speak before, she's the current executive director. So specifically with the Attorney Disciplinary Commission, that involves allegations of attorney misconduct, and we have staff attorneys who investigate and prosecute the allegations of misconduct. And then our office also will provide ethical guidance and advisory opinions to lawyers. And every time I give a presentation, I like to remind everyone what the purpose of our commission is, because I think sometimes people get the misconception that we're just out here to punish and go after lawyers. But really what we're doing is we're trying to protect the public, the court, other members, other attorneys from misconduct on the part of attorneys. And also we're protecting attorneys from unwarranted claims of misconduct. You can kind of see if you look at the Supreme Court's annual report, which came out about the number of complaints that we get and have to review every year. And a good resource just for you guys going forward is our website. On there you can find attorney and judicial discipline decisions. Our office also publishes advisory opinions every quarter. And I would say there was one that came up recently within the last month. I don't know if anyone's read it. It had to do with ex parte communications, and it was really well written, and it gave a lot of hypotheticals within it. And a lot of them had to concern family law practice because we get a lot of questions about ex parte communications in that area. And so I would suggest, since I think a lot of you guys might be family law practitioners, that would be worth reviewing. We also have this portal on there that you can submit informal guidance requests if you do have a question. And the whole point is we would rather hear from you on the front end with a question rather than seeing you on the back end on a disciplinary decision. So I wanted to start first with two recent cases across the country that had to do with attorneys' bad online behavior. The first one was in Colorado, and this came down in August of 2024. There was a Colorado attorney, AK, and he received a state 60-day suspension for posting as a judge and a former deputy district attorney in blog comments. So the blog itself was called Much Ado About Something, and it was a blog that was maintained by a former district attorney, deputy district attorney. And in this instance, AK made 2 comments in response to the post. So the first one was attributable to a county judge that read, and I don't know what this quote means, it doesn't make any sense. It was all in capital letters that said, "Da got that dope." And then the second comment he tried to make was attributable to a former district attorney that read, "Shut the F up." So in order to post on the blog, you had to associate your comments with an email, and you had to give them first to the moderator for approval. So with one of the comments, the AK used the email, which was even more bizarre, hottubtimemachine@gmail.com. And then the other comment was associated with the email of the actual deputy district attorney that AK was impersonating online. Luckily, the moderator did not approve the comments on the blog, and he was reported to the disciplinary authorities in the state. And so in this instance, there was an agreed violation that AK had violated Rule 8.4C, which is professional misconduct for a lawyer to engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. So even though his posts were within the context of him being a lawyer, representing a client in his work as a lawyer, it was just him personally posting on those comments. He still was charged with an 8.4C violation. The other one, and I think this was also picked up by the ABA, is a complaint that was filed in August of 2024 against the Illinois attorney who was charged with violating different rules of professional conduct. And in this instance, he was posting negative reviews of his opposing counsel in a very contentious case. But then he was also posting favorable online reviews that he was making up of himself on a couple various lawyer review websites. And the complaint is very detailed. They did a great job of going through all of the reviews and actually picking out what emails he was using to post these reviews. And they calculated from August 2019 to May 2024, the attorney submitted at least 28 false 5-star reviews of himself. So I went through the complaint because it lists them all out. I was kind of looking at the ones, he made up clients in specific instances where he was talking about these imaginary cases and made stories up. And then he had kind of these weird general comments about he was a hard, aggressive litigator. He knows how to stick it to the other person. I thoroughly loved his skills. I don't know how that attracts clients, but he just had a whole list of comments and reviews he was making up. Then, as I said, he was doing negative reviews of his opposing counsel, but what he was doing was that he was posing and claiming to be a client of the opposing counsel. The other thing that I wanted to make you aware of that was also addressed in the complaint was the communication and the emails he was exchanging with the opposing counsel in this case. And he was also charged with violations regarding some of those exchanges and some of the comments he was writing in the emails. So some of them he was putting in the email, "You might be a complete idiot. You are an absolutely terrible human being, and I hope you and your loved ones have to endure the same harassment that I have undergone one day." So that was kind of more problematic behavior that he's been charged with in this case. So those kind of people, I think, are the more extreme ones, the Liam Neesons. And we know that most of you and most lawyers are never going to intentionally run afoul of their ethical obligations. And instead what we may have is attorneys that have ethical issues that might be due to inadvertent actions that were performed with the best intentions. And probably you guys all know this, but what I always say, just like if you're writing a discovery dispute email, if you're going to respond to a review, don't do it right away. Take a break, write a draft, take a break, take another break, review it, and maybe have a trusted colleague or a family member Just remember, just don't be Liam Neeson and taken when you're responding to a review. So I kind of want to talk about the 2 decisions that have come down in Indiana regarding online reviews. I put this one up here because I do like to see funny reviews, and I was looking at those. My friends have a brewery down in Indianapolis, and so sometimes we like to talk about funny reviews. Like, they had one recently that was like 4.8 stars, but like positive comments, and so we were kind of joking about like why it was 4.8 and they didn't give them 5 stars. Like, what was the difference with the 0.2? So I'm sure people that might have businesses, or even some of you might have already had this problem where you get a low star, but there's positive comments. So the first one was in 2015, and it was the matter of DS. And I will tell you that how DS handled his reviews on the internet was probably one of his least of his problems in his violations of the rules of professional conduct, because he in total violated 16 rules of the professional conduct, and that included stealing $150,000 from his clients. But I think the opinion is important because this is the first time we're seeing how the Supreme Court did discipline an attorney and did find violations for how they were responding to online reviews. So with one of the counts in the complaint, DS was charged with false or misleading advertising and then also revealing client confidences. And in this instance, you had multiple problems with DS's online behavior. So first, he was manipulating his attorney reviews online by monetarily incentivizing positive reviews, and then he was punishing his clients who were writing negative reviews by publicly exposing confidential information when he would respond to the reviews. And there was actually an email that he wrote to a client that I was blown away when I saw it. So he even wrote to a client, and I do not pay for reviews, but to be clear, the people who write positive reviews almost always have this really weird hiccup in their billing that almost always goes lower than the bills for those people who don't write reviews. It's the weirdest thing, Jim. They almost always pay less, and the more over the top the review is, and the more sites they post it to, the lower the bill goes. Interested? If so, I'll make it easy for you. Click on this link. And the same day, Jim wrote a positive review about DS when he received that email. The other thing was that DS actually admitted to other associates there at his office that he had a ton of experience in getting bogus reviews removed from the websites. And then actually in another email, what he told another associate was that when how he likes to respond to reviews, he wrote, "I don't always claim to be mature or 100% honest in what I say in response to bad reviews." So the other problem that DS was in trouble for with his online behavior was how he responded to former clients' negative reviews on him. So DS had a former client by the name of NR, and NR posted an anonymous negative review of DS. DS saw it, and he incorrectly assumed it was another former client by the name of CS. So when DS responded to the review, he identified the wrong client by her first name because he thought it was CF. And then he wrote this long, unhinged rebuttal in which he revealed confidential information about CF and his representation of her. And then he also falsely claimed that he was not her lawyer and had never spoken to her. And then he had another former client named MB who also posted an anonymous negative review of DS. And in that instance, DS responded by identifying MB by her first name. He had also represented MB's other family members in other matters, and he mentioned that in his response about these specific family members. He also made false statements in his response that MB had sued him and that she was a divorced client. So as I said, he had a lot of other problems, but in terms of his online behavior, the incentivizing clients to post positive reviews by giving them discounts on the bills, and how he responded to the online reviews, he was charged with rule violations as to that specific behavior. So it was Rule .1.9C2. and that has to do with your duties to former clients. And that was revealing otherwise confidential information about his former clients' cases in response to clients' negative reviews. He was also charged with violating Rule 7.1, and that was due to him making misleading communications about his services, including manipulating his online reviews. And then again, he was also charged with 8.4C because he made false statements in response to his clients' online reviews. And as a result of everything, this was not, again, all related to his online behavior, DS was disbarred. Now, more recently, you have the matter of SW. And just so you know, this wasn't a discipline just because SW responded to an online review. It was how there were different multiple missteps that SW took along this case in dealing with a negative review on Google. So in this instance, BC had retained his client, BC had retained SW to represent him in a matter. In that case, it should be on February 17th, 2021, the parties reached an agreement whereby the underlying case would be dismissed in a year, provided BC met certain conditions. BC met the required conditions, and the matter was dismissed then 1 year later. On April 27th, 2023, BC, the former client, posted a Google review concerning SW's firm and gave the firm a 1-star rating. And in the Google review, it was pretty innocuous. It was BC just indicating that there were problems with the communication with SD and his firm, and just kind of speculated that the communication problem was attributed to SW being busy. So it wasn't a horrible review in terms of what he had said about SW and his representation of him. So the problem becomes how SW responded to the review. And it's kind of, as I said, a series of missteps. So the first problem is, over a period of 4 days, SW called BC, emailed BC, and reached out to him on social media and made multiple demands that BC remove the review. And in these communications that SW had with BC, he used derogatory language. It also contained profanity, and he threatened BC with a defamation lawsuit if he didn't remove the review. The second problem, well, then BC refused to remove the review. So the next problem came with how SW actually responded to the Google review in itself. Now remember, the review is public, and in SW's response, he actually revealed the case title and the number involving BC. He identified the type of matter that there was, and he also wrote and identified that the matter was one which could potentially negatively impact BC's career, and announced the results of the matter pursuant to the agreement. And when he wrote the review, he or the response, he never really even addressed BC's concern about the lack of communication that allegedly took place. However, not satisfied with just that response, the next misstep is SD then goes ahead and files a lawsuit against BC, his former client. And he filed that lawsuit, it was a defamation lawsuit, and he filed it in Indianapolis and Marion County when all of the events took place up here in St. Joseph County during SW's representation of BC. And in the complaint that SD filed, which was a public complaint that you could find online, SW again identified the charges that BC had faced. He provided the cause number and the date that the charges were filed. He revealed BC's employer in the complaint, including BC's position at his job, and he speculated within the complaint that if the matter was not dismissed, BC would have likely been terminated by his employer. SW also again made reference and revealed how the matter had been resolved through this agreement. So in this instance, the commission ended up charging SW with one rule violation of the professional conduct, and then also a rule violation under the admission and discipline rule. So again, you can see there's a Rule 1.9C charge, and this was because SW revealed confidential information that he had learned within the course of his representation of BC. You know, his employer, his position, the fact that this case was resolved and how it was resolved. And then he was also charged with violating Admission and Discipline Rule 22, Oath of Attorneys. That one you don't see that often, but it's kind of for attorneys, and this was particular because SW was using profane and derogatory language in his repeated demands to BC to remove the review. And so when he's using that language, you are, violating your oath of attorneys that you all take when you first get sworn in. So in the instance of SW, the parties settled the matter and the settlement was approved by the court, and SW received a 30-day suspension, stayed subject to the completion of at least 18 months probation with JLAT monitoring. JLAT, for those of you who don't know it, is the Judges, Lawyers Assistance Program. So it's like a probation period. So just some other, before I turn it over to my colleague, just some other rules to think about, because we kind of talk more just about your duties to your current or former clients, is dealing with third persons. And so I was kind of looking through the rules and thinking about other rules that may come up that you need to think about when you're deciding how you might respond to something on social media, or how you might respond to a Google review. Rule 4.4a are your duties with a third person, and that a lawyer shall not use means that have no substantial purpose other than to embarrass, delay, or burden a third person. And you're kind of still seeing this. I was reviewing a handout with discipline decisions throughout the country in the last year and looking at social media where attorneys have gotten into trouble. And unfortunately, we still have attorneys that are going on social media and maybe posting disparaging comments about their opposing counsel on Facebook or online. You could say the same thing, that it's been done for, in the context of like domestic relation cases, about ex-spouses, ex-partners. So that's just something to keep in mind, if you are responding about respecting the rights of a third person. The other thing, as I kind of indicated, is there are some rules at the end. It's 8.4C and 8.4D, and these rules become applicable even if your comments are not within the context of representing the clients. You still could be charged with a violation if you're engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation, or if your conduct may be prejudicial to the administration of justice. The other thing is you may want to remember and be aware of is that you might have a ex-spouse or an ex-partner posting a negative review of you online, but they might be still represented by counsel. So if you're communicating with them or asking them to take down the review or to change it, remember they still may be represented by counsel, and you could be running afoul of Rule 4.2. Lawyers also have duties with response to how they deal with unrepresented persons. The other thing you need to be careful about is kind of going into the rules that have to do with advertising, is making sure that you're not making false or misleading communication about your services when you're responding to a review. And that involves also to the advertising requirements presented in Rule 7.2. So I'm going to hand it over to Olubunmi, because she's going to do the more fun stuff versus I feel like I'm the more scary, like, don't do these things. So she's going to help you solve problems.
Okay, so good morning, everyone. I am Olubunmi Ijose, and again, I'm with the Disciplinary Commission. So we are now living in a digital age. So what does that mean? Say you have a potential client, and the potential client is looking for a personal injury attorney or a family law attorney or an immigration attorney, whatever attorney that they need. So the first thing today that the average potential client will do is go immediately to Google and what? Type in personal injury attorney or family law attorney, whatever type of attorney they're looking for. And after they do their search, a lot of different attorneys or law firms are going to pop up. They're going to click on those firms, or they're going to click on those attorneys, and they're going to look to see what are the Google reviews. They're going to allow those Google reviews to be a deciding factor as to whether or not they are going to potentially hire you or hire that particular attorney. And so what does that mean? That means that online reviews are very crucial in today's age. And so you want to make sure that you are staying abreast of those online reviews so that you can make sure that your reputation is remaining intact, whether it's based on positive reviews and or negative reviews. Therefore, it is important to know how to respond to online reviews. First, you must be professional in your response. You want to make sure that you are always maintaining a professional tone. You also want to make sure that you are responding in a timely manner. If there are any negative reviews, you want to make sure that you mention steps that you have taken to fix the issue. And you don't want to be defensive. You definitely don't want to be confrontational in your language. So let's talk about the Opinion 496. Essentially what it does is that it advises the lawyer about how to maintain confidentiality. It also provides a professional response in terms of how to not reveal any confidentiality information, because you want to make sure that you're not violating the client-attorney privilege. Lastly, it emphasizes how important public responses are to negative reviews, and it brings about or highlights the importance of finding resolution privately instead of trying to find resolve publicly on Google or whatever that negative review might be. So let's talk about how to navigate confidentiality and legal ramifications. First, when responding to online reviews, the attorney needs to make sure that they don't violate attorney-client privilege. That is something that is very important. I think you heard Jill discuss it earlier with a couple of the other cases. I think it was SW. He definitely violated attorney-client privilege by even mentioning the client's name. It might not seem like that's violating confidentiality, but if they're providing a review anonymously, you should definitely want to make sure that you're responding to that person anonymously as well. You also want to make sure that you avoid any potential legal implications and make sure to avoid providing specific details. As mentioned earlier, for instance, with the SW case, providing the name when it was an anonymous review. So let's talk about some case studies. And with the case studies, we're going to look at examples of client reviews, attorney responses, and potential outcomes. Hypothetical number 1. This is a 1-star review, and it says, I hired this law firm for my personal injury case, and they did absolutely nothing for me. I was left in the dark the entire time and had to keep calling them for updates. Complete waste of time and money. Avoid at all costs. What was the attorney's response? Dear reviewer, thank you for sharing your experience. We sincerely apologize that you felt left in the dark regarding your case. Communication and transparency are important to us, and we regret that we didn't meet your expectations. We aim to keep all our clients informed, but clearly in this instance, we fell short. We would appreciate the opportunity to discuss your concerns in more detail and resolve any misunderstanding. Please reach out to us directly, and we will do everything we can to ensure your concerns are addressed promptly. So, what are some things that we see as it pertains to this hypothetical? 1, the attorney thanked the review. 2, the attorney apologized. The attorney also expressed the importance of communication and transparency. The attorney provided a resolution privately, and the attorney maintained a professional tone. But more importantly, the attorney took accountability. So, let's talk about some potential outcomes. If the attorney promptly responds and has a sincere conversation, the attorney may be able to clarify any misunderstanding, provide a detailed explanation of work already done, and provide a plan for better communication moving forward. A second outcome, or if after doing those things, the attorney continues to remain dissatisfied, the attorney can agree with the client to end that attorney-client relationship. And if in doing so, it's best that the attorney recommend another firm or an attorney for that client to pursue. A third outcome is if the response is not followed up with a meaningful action, the client can leave another negative review. They can go back to the same review that they had, and they can provide an update. I'm sure you guys have seen when you look at Google reviews, even if it's just for a restaurant, you might see update. And the providing an update may be whatever the restaurant may have done to take action privately to satisfy the customer. The same would go here. You want to make sure that you respond in a meaningful manner. And if you're not, they're going to go back and they're going to provide an update. They're going to provide another additional negative review, or they're going to go to other platforms and put reviews or negative reviews on those platforms as well. The next hypothetical. So this is a 2-star review, and it says, the attorney was knowledgeable, but the case took way too long to resolve. It felt like the firm wasn't prioritizing my case. I had to constantly follow up, not what I expected for the amount of money I paid. The attorney's response, dear reviewer, thank you for your feedback. We are glad you found our legal expertise helpful. But we are sorry to hear about your frustration with the timeline of your case. Some legal matters can take longer than anticipated due to factors outside of our control. But we understand how delays can be stressful. We strive to keep all of our clients updated and informed throughout the process. And we apologize if we did not meet your expectations. Please contact us directly so we can address your concerns and work towards a resolution. And again, what do we see here? We see that the attorney responded with a professional tone. They responded with a positive manner. They also apologized. They were transparent, and again, they took accountability. So what are some potential outcomes? If the attorney responds promptly, the attorney can help the client understand the complexities of the case and promise to improve communication, which could potentially lead to the client being more patient with the process. A second outcome is the attorney could respond promptly, but the client continues to be unhappy. So say the client is unhappy, but the attorney continues to represent the client. This is an opportunity for the attorney to try to smooth things over and make sure that the remaining process of the case goes smoothly for the client. A third outcome could be, even after providing explanation, the client may switch attorneys. And again, if the client wants to switch attorneys, oh, I'm sorry, I didn't put it up there, my apologies. And again, if the client wants to switch attorneys, the attorney should assist the client in having a smooth transition by providing any type of recommendations for a potential law firm. And then lastly, if not properly addressed, the client can continue to feel neglected and create additional negative online reviews. Again, they can do an update on the review that they already had, or they can go to a different platform. And the final hypothetical, this is a 2-star review. I thought this firm would help me win my case, but they just kept asking for more documents and dragging things out. I didn't feel like there was a clear strategy, and I'm disappointed in the lack of progress over the months. Not impressed with how this was handled. And what's the attorney's response? Dear reviewer, thank you for sharing your experience. We are truly sorry to hear that you felt frustrated with the progress of your case. Legal cases can sometimes require extensive documentation to build a strong foundation, but we understand how this can be perceived as a delay. We strive to keep our clients informed and develop a clear strategy for every case, and we regret that we didn't communicate this to you effectively. We would appreciate the opportunity to review your case and provide a clear timeline and explanation. Please reach out to us directly. And again, for this hypothetical, we see that there was a professional tone, that the attorney apologized, that the attorney provided a reason for why the case was taking so long, and that the attorney took accountability. And finally, the outcomes. 1, the attorney should respond quickly and help the client understand the process better by providing a clear strategy and timeline for the case. This will give the client reassurance and make them feel like they have been heard. If the attorney improves the communication, the attorney can provide updates and give regular status updates with the case, and the client will feel more informed and involved. Third, if the attorney fails to address the client's concerns, the client could request to speed up the process of the case, which could affect the attorney's performance. Or alternatively, maybe the attorney might need documentation. The client may decide to prolong providing the documentation, or the client may decide to not provide it at all, which would further provide frustration from the client to the attorney, and vice versa, the attorney will start to be frustrated with the client. And finally, if the client believes that the attorney lacks strategy and or is dragging out the case, the client may leave the firm. This could happen if the client is responding too slow, or maybe they completely ignored that bad review altogether. As I mentioned earlier, it's important that you respond to negative reviews in a timely manner. And so what you don't want to happen is you don't want to see a negative review sitting out for weeks or months or even years and you never respond. Even if you have negative reviews on Google or whatever platform that you might be on, oftentimes people or potential clients, they want to see how did you respond to that review, or was there any type of resolution. So it's always good to make sure that you respond in a timely manner. So let's talk about fake reviews. How do you know a review is fake? Well, we're going to look at vagueness. If the review is vague, there's a chance that it might be fake. We're also going to look at whether or not there's repeated phrases that are being used. Or if you see short one-liner reviews, that's another signal that the review is fake. You might also see unrelated content, so it might be something that doesn't even involve the legal word or the legal field. Or maybe you might see 1 star or 5 stars. Typically, people don't do 1 star or 5 star. The average person does 2 stars, 3 stars, or 4 stars. And then finally, the reviewer history. If you see a bad review, you can oftentimes click on the reviewer's name or their little icon, and it'll take you to a page that shows you their interaction online for that particular platform. And you can be able to see whether or not the reviewer is constantly always just putting negative reviews for different businesses. That will also alert you to whether or not a reviewer is a fake reviewer, or what some people call a bot. So how could you respond to a negative or a fake review? You can respond by saying, "Thank you for your feedback. I couldn't find any record of me representing you. Could you please provide me with more information so I can resolve the issue?" And then finally, once you're certain that the reviewer is a bot or is a fake review, you want to make sure that you report it to that platform. So what are some best practices for proactively managing online reviews? Or online reputation, excuse me. You want to regularly track mentions and reviews online. So how do you do that? By doing Google alerts on yourself. Google alerts on yourself, Google alerts on your law firm, and also if you have a Google business already set up on Google, you will get alerts back from Google letting you know whenever someone has posted a review. You also want to be engaged with your client by keeping an open line of communication. I know a lot of times we can be busy in our day-to-day work life, but if you can try to stay open with your client by maintaining that open line of communication, that will really help in having a positive review instead of your client being slightly dissatisfied or feeling neglected. And finally, you want to create a positive client experience, and that goes right back to having open communication. That's really the key. So, developing ethical protocol and enhancing skills. How can we develop a response protocol? We can do that by having a template. In law firms, we have templates. They make life so much easier. So, the same thing applies to how to respond to Google reviews or other reviews. You want to make sure you have a template, and that a template meets the Opinion 496 guidelines. You also want to train your staff on best practices for engaging with online reviews. And you want to have resources readily available that outline ethical standards for managing online reviews, and that goes back to the opinion 496. In conclusion, we've discussed how to manage online reviews and the importance of responding in a timely manner. You don't want to ever let negative reviews sit out there for too long. You want to make sure you tackle it and meet with the client privately and make sure that you're trying to provide some type of resolve to meet the client's satisfaction. It's also important to follow the opinion 496, as that provides a guideline for how to respond to negative reviews. And you want to make sure that you foster a positive relationships with your clients, so that leads to positive reviews. But you genuinely want to do that. You don't want to just do it so you get positive reviews. You still want to be an attorney that genuinely, as a human being, have that open communication, because you want to do the best job that you can. Thank you.
So one thing, we will take questions if anyone has questions. I would just say with the ABA formal opinion, it's not like legal precedent within the state of Indiana, just like other states' decisions or opinions are, but it's a really good one because it does kind of go in depth when you say about, it's very specific about it. So can't say, you know, that you can cite that, but it's good for you to review, because sometimes in our advisory opinions, we don't address every issue. It's kind of what we see currently happening. Like I said, with the ex parte, that's something that continues to come up on a frequent basis every year. So just a caveat. And then if you guys have any questions for us, we're happy to answer them to the best of our abilities. I was excited for lunch.
That's it. Looks like people are on.
That's why I was hungry. And if you have questions in the future, like I said, there's the informal guidance portal. The instructions are kind of on there. We get them from attorneys. They're hypotheticals a lot of times. The other thing is, if you guys feel like that there is something that's coming up more frequently in your practice here in St. Joe, you can reach out to me, and I can, I can do my best to address it and pass the message on or send some guidance or any cases. So again, we don't want to be scary. We don't want you to be scared of us. We would rather have this open communication this way and give you resources and supports.
Thank you.
Thank you.
Ladies, thank you very much. I am told by the experts that lunch is available in the small conference or small courtroom, so please feel free to make your way there and enjoy.
Can I take your suggestion